In a breach of contract case, one party might want to introduce extrinsic evidence, meaning evidence from outside the contract, to show that the parties intended something other than what the contract says. The introduction of such evidence is restricted by the parole evidence rule. We explore that rule, and one of its exceptions, in Beatley v. Knisley. Students Catherine Knisley, Jacqueline Wanner, and Julianne Irene wanted to rent an apartment near their college campus. Levon Baker, an agent for Jack Beatley, showed the students one of Beatley's properties. After communicating with Beatley, Baker told the students that they needed to satisfy 3 conditions before the lease would become binding. First, each student would need a guarantor promising to make payment if the student did not. Second, the students needed to submit a deposit. And third, the students needed to find a 4th tenant. The students completed rental applications and subsequently signed a lease. The lease didn't mention any conditions to its effectiveness. It simply stated that tenants may be required to have guarantors and pay deposits, and that the unit wasn't meant to have more than 4 residents. The students never met the conditions and never took possession of the apartment. When Beatley sued them for breach of the lease, the students argued that there wasn't a binding contract because they didn't satisfy the conditions precedent to its existence. Beatley countered that the parole evidence rule prevented the students from introducing evidence of oral conditions precedent imposed prior to signing the lease. The trial court agreed and granted summary judgment in Beatley's favor. The students appealed to the Ohio Court of Appeals.